bono lawyers specifically to work and better the conditions of Indian women. Coming over to what is the scenario of Indian women. And it is such a sorry state of affairs that Indian women's status hasn't really changed over multiple decades now. So if I have to paint a picture for all of you, and I begin from 1970s onwards. So from the late 1970s onwards, up till the initial bit of 1980s, rather even the initial bit of 1990s itself, we used to see multiple bride burning instances in India. And owing to that necessity, the legislature had brought about a legal provision of Section 304B in the Indian Penal Code. Now, that section made it a punishable offense for dowry death, right? And dowry death, and there was another presumption made in the cases of dowry death that if a woman is dying within the first 7 years of marriage, it will be a presumption taken up against the husband that he's the culprit. And it is him who has to prove otherwise. So, owing to the necessity, do the laws keep on changing? That is what I'm intending to convey. Laws are entirely based on public morality, health considerations, the necessity of that point in time. So these are necessitous laws pertaining to the conditions of women that were made, and I'll be discussing them one by one. So first being that initially, in the entire span of 80s and 90s, we saw multiple bride burning instances. So violence, especially domestic violence, used to occur in the guise of physical violence, right? It is only after the 90s that we saw a progression into mental violence taking place and more cases of emotional abuse also taking place. Now, owing to that, in 1983, another penal provision was added, which was 498A. Now, 498A talks about cruelty by husband and the relatives of husband. And kindly take a note of this, you all, that 498A today is the only penal provision in India for crimes of violence against women when it comes to domestic violence. It's the only penal provision. This provision says that whoever commits cruelties, the husband or their relatives, they can be penalized with a fine and a maximum imprisonment of 3 years. Now, what is cruelty? This act defines cruelty as a willful conduct or negligence taking place on the behalf of the husband or any relative of the family. That essentially causes health concerns to the woman. Now, those health concerns can be both physical and mental. It also states that cruelty will encompass within its purview harassment that takes place specifically for dowry related demands. So now we have this established law that if a cruelty to this nature, as I stated, is taking place in the domestic household, the woman has a recourse to this particular section 498A, where the husband can be penalized and put behind the bars for his acts. Now, coming over to domestic violence in its entirety. So, this term domestic violence has nowhere been used in the Indian Penal Code. It was only after the 2005 Act, which was the Domestic Violence Act, that the word domestic violence came into the public portal. It was used specifically. And this 2005 Act, and the broad term for this is Protection of Women Against Domestic Violence Act. And as an abridged name, we often pronounce it as the Domestic Violence Act of 2005. Now, what was the need for this act to come into the picture? It was needed because women, as I've mentioned it to you, we remain in a patriarchy and we remain in this particular sorry state of affairs even in our 2000s today, that we require segregation of women for them to be safe. For example, in the Delhi metro, we have a separate women's compartment. So why do we have to compartmentalize our women in order to safeguard us? But then this is the sorry state of affairs. So even in this case, we had to compartmentalize our women in order to protect them better. So we compartmentalized a specific legislation only for the woman. Uh, uh, in the cases of domestic violence, of course. Now, Does this mean that men do not have recourse to anything if at all they are facing domestic violence of any sorts? So that is not the case, right? We have special provisions for women because our constitution mandates our legislature to formulate these special laws for women under Article 15, Clause 3. We are supposed to provide women with this kind of equality and this kind of a segregated treatment so that they are able to be equal to men. So, which is why we have the separate legislation in place. But then, if at all they
Hmm.
face any kind of
They
domestic
are they are
violence and domestic,
they are
uh, I'd request you all to kindly switch off your mics because it really distracts the flow of my arguments here. Thank you so much. So, I was telling you that this is not to say that men do not have any legal recourse available if at all they face domestic violence. Because what is domestic violence? Anything that happens within a shared household, within the confines of your home, is domestic violence. It can be against the woman, it can be against a man as well. It can be against the elderly or the children. So, for elderly, we have separate provisions under the law. For the children, we also have certain segregated provisions under the law. But, and for women, we have the Domestic Violence Act that we would discuss in detail. But what if a man faces, we have heard of wife beating instances, but what if a husband beating instance